in between the first appearance and then the trial date. And again, they set a date for trial. It doesn't always mean you're going to go to trial. Municipal court, I don't know the exact figures, but they're up there with the whole criminal law process in general of, 90-some-odd% of the cases result in a plea. Very, very few of them actually go to trial.
And just to review, a plea means?
A plea agreement is a process where on the date of trial, so we can move forward now. We have first appearance, we have the time in between of getting discovery and preparing defenses, looking for whether there's defenses to the case, which by the way, they may be absolute defenses. They may be the ability to say, look, we can beat this charge, you really should not be found guilty, as long as everybody's doing their job properly in the court. But it might be not a slam dunk, but enough to maybe induce the prosecutor to enter into a plea agreement. They might say, listen, there's weaknesses in their case, and maybe they don't want to go to trial. But maybe they're not going to throw in the towel and dismiss all the tickets against you. But I think we might be able to reach a resolution here.
Just while it's in my mind, is it possible for someone who chooses not to get an attorney to order discovery? Can they get discovery on their own?
Absolutely.
Okay.
Yeah, you're entitled to represent yourself in municipal court. The legal word is pro se. It's Latin for, on your own or by yourself. And you're representing yourself pro se, and you can go in and you can bring your own case in municipal court. You can get discovery. You can subpoena witnesses. You can have a trial that night. Talk about the trial process later, but you don't have to have counsel at that level of court. And it's a bit of a diversion, but we forgot to mention one other type of summons it can issue that's very, very becoming much more common and becoming much more frequent, and that would be a citizen's complaint. So the whole process can actually be initiated by an individual. The officer doesn't issue a complaint, but an individual has a complaint against another person. My neighbor harassed me, or I believe there was a motor vehicle violation that I witnessed, and there was no officer around to see it. So people can actually issue their own citizen's complaint, and they become responsible for the summons or the complaint issuing. And at that point, there's a decision by the municipal court prosecutor whether he or she is going to take up that summons or complaint and prosecute it. And if they're not, the person that issued the citizen's complaint becomes what we call a private prosecutor. They actually can prosecute the complaint. They can be the prosecutor and bring the case and try to have the defendant.
Even if they're not a lawyer?
Even if they're not a lawyer. But more and more, depending on some circumstances that are too involved to go into now, sometimes people are actually hiring their own lawyers to be prosecutors. So in courts, I've been a defense attorney, but I've also been a private prosecutor for somebody and actually stood in the shoes of the municipal court prosecutor and prosecuted somebody's citizen's complaint all the way through a trial.
So you closed there with all the way through a trial, and we only have about 5 or less minutes left.
Sure.
Can you tell us in a nutshell what the rest of the procedure is that we can expect to see?
When you go in for your trial date, the first sort of foundational point is first thing is, I should say this, you don't get a jury in municipal court. It's a judge, municipal court judge. They're appointed each year by the township. They're reappointed on a yearly basis. And it's usually an attorney who probably has a private law practice. There's a few that are doing enough municipal courts that's all they do, but usually it's a private attorney who then works as a municipal court judge, maybe somebody who's an attorney in the town often. So that's who your trial is before. Don't get a jury in municipal court. But you are entitled to all the rights that you have in Superior Court and any other court, well, at least a criminal court. You have the right to remain silent. The state has to prove its case against you beyond a reasonable doubt. You have the presumption of innocence. You can call witnesses. You can cross-examine witnesses that are called against you. So you have that full range of rights, just like in any court, and the trials are conducted in that way. On the actual day for trial, again, typically the process is plea negotiations. So you go in and the lawyers go in and see the prosecutor, or you go in and there's a line for people who want to go in and see the prosecutor, and that's where you go and see whether there's an ability to strike a plea agreement with the prosecutor, either because of maybe some weaknesses in their case, or sometimes just because it's more beneficial to everyone involved. The process of negotiating a plea is recognized by our state Supreme Court as not only completely acceptable, viable, but absolutely necessary in the municipal court and the criminal law process. And it's an accommodation. It's acceptable. It's an accommodation where the state may not have to spend the time and the resources of taking something all the way through to a trial and completing the whole process. And in return, what they're giving is a reduction in charges. Maybe they can throw out some of the charges if there's more than one. Maybe a charge can be modified, the obvious one being points. Their speed limit can be pled to a lower speed limit, so you have lower points, those types of things. Sometimes the fines and the penalties can be negotiated as far as the plea agreement. Driver's license loss, whether, how much, all of these things can form part of a plea agreement.
Well, John, we're coming to the close of our program, so I wanted to say in our remaining few moments, a plea agreement is not available on all cases, right?
No, not at all. Some cases, either you're not going to, or the prosecutor's not going to allow it, or perhaps maybe even the judge won't accept the type of plea or a plea at all, and then you have to go to trial.
Okay, so I think we're going to cover trials in another show because that would take so long for us to go through. But just wrap up for us, for people who may be watching and they have a ticket now and they're thinking about going to court and they understand the process as you've outlined it now, but they just want some closure about how this all wraps up.
Okay. The first thing is go to the state's website. There's a lot of great information there. The next thing is contact the local municipal court because they also have information. There's pamphlets that cover a lot of the topics we've already discussed, your rights in municipal court, obtaining indigent representation if you want to get a public defender, or even sometimes lawyers will do cases on a reduced rate, and you can find out a lot of information, from those sources. But essentially you need to really look at what the case is, what you're facing, and have a clear understanding of that, but also in light of your circumstances. So the obvious one being a 2-point speeding ticket may mean nothing to one person, and it could be devastating to somebody else if they have a bad record, basically, or if their insurance company is going to act a certain way. And the other source of information is most attorneys will meet with you for a consultation, for a free consultation. That's what I do in my office and my firm does, and it's pretty common for this type of thing because it's not a very long discussion. You can usually get a pretty good idea of what's going on in a half an hour's time. So call an attorney, speak to somebody about it, find out what your rights and remedies are.
John, thank you for speaking to us about this. I greatly appreciate it. And thank you for tuning in to Law Talk Today. I'm Dan Agatino, your host.